only for purposes of administrative action. Am I correct?
Yes, I assume that that was the reason it was brought to your attention. And it's a matter that we have also explained in the affidavit. Yeah.
Okay, but for the judicial hearing of the matter is still supposed to be before Judge Mateka, and my understanding is that the direction is supposed to act today for directions on hearing of the application by Ms. Bagi.
My Lord, we can have a date for before her.
What I will, Ms. Badia, I thought it would be supposed to appear before her today.
Yeah, that's my Lord. My Lord, what I was asking.
Yes.
Perhaps we can have the file placed before her so that we take directions.
Correct.
My Lord, so, because there are some documents were, yes.
What I will do, I will arrange right away for this file to be taken to Justice Mateka, and then her assistant will contact both of you with a Zoom link so that she can give you directions.
You're most right.
Okay, thank you. Thank you.
Criminal Revision number 208 of 2020, Sudi Oscar Kipchumba versus Republic through NCIC.
All right, good morning. I see Mr. Karuri for the state.
Morning, my Lord. Yes, I'm present for the state.
Okay. I am guessing that is Mr. President, but you need to adjust that camera. You could just sit. It's okay.
Yes, thank you, my Lord. Most of us are accustomed to speaking when standing because we'll go on, my Lord. That's okay. Thank you, my Lord.
Yes.
My Lord, for the applicants,
yes.
Nelson Harvey, Isaac Terrer, Hilary Sigay, Bernard Ngetich, Honorable Onesimus Kipchumba Murkomen.
Just a minute. After Sigay is who?
After Hilary Sigay is Bernard Kipkoech.
Okay.
Ngetich. Honorable Onesimus Kipchumba Murkomen. Nathan Tororey. Thomas Ruto. And there appear to be no gender balance in this representation, my Lord. We have Jen Masai. We have Professor Wajakoya, Oliver Kipchumba, Collins Kiprono, and Manasseh Tumen.
Manasseh?
Men.
Yeah.
And lastly, Alan Kosgei, Honorable.
Okay, and Mr. Sudi is there in the police station. Good morning, Mr. Sudi.
Morning, Your Honor.
Are you doing all right?
I'm good.
In the circumstances. All right. Okay. Mr. Karuri, this matter was filed under certificate of urgency yesterday. I gave directions that need to be served and that we hear it today in the package. I hope you were served.
My Lord, I confirm was served yesterday at around 4:30 p.m.
Okay. That's good. It was presented to me at about 3:30, so that was a quick service.
Yes, my Lord.
Okay, so are you ready?
I'm ready, my Lord.
Okay, and Mr. Harvey, will you be leading the team?
My Lord, three of us will speak. We propose not to take more than 25 minutes.
In total, I believe.
in total.
Okay.
My colleagues will take 10 each in prosecuting. Then after my colleague, Mr. Daniel Karuri, has responded, I will reply in 5.
Okay.
English time, my lord.
And Mr. Karuri is famous for his succinct address to the court. He has never been known to take more than 15 minutes.
My lord, I'll be very brief. 5 minutes at most.
Okay. Thank you, gentlemen, and thank you for agreeing to these directions. It's a fairly a concrete matter, so we don't need to spend a lot of time. And if possible, I would like to, given the nature of the case, I would like to give a ruling today, later today. So if you can keep to those timelines, it will enable me to keep time. Please note that for any extra minute you use, it amounts to about 10 minutes of writing a ruling. So, so you might well take yourself out of today if you keep talking for very long. Okay?
Thank
All
you.
right. So
We'll start right now.
All right.
Yes, my lord, unfortunately I have to stand. My lord, the application before you is the one dated the 17th of September.
Sorry, please, who's speaking?
Mr. Toroy, your lordship.
Sorry.
Yes.
Okay.
Your lordship, the one before you today is the application dated the 17th of September. We are basically taking 2 prayers, your lordship. The first one, which is that we would not be pleased to admit to the boss facility bond. Contact must be reasonable to the court. And second, the lordship, that the court examines the legality and the propriety of the orders issued on the 16th of September 2020. My lord, we rely primarily on the ground set out in the application, as well as the next affidavit of Oscar Sudi. And we also filed our skeleton argument, which I believe is on record.
No, I've not seen the skeleton argument.
It was placed before the registry this morning. Probably the same will be brought to you later in the day. But we did file our skeleton argument.
Okay, Ms. Bauer, have you seen the skeletal arguments?
I've not been given any.
Okay, do you have someone else in that boardroom or you're all alone?
I can send Bugwa.
Please send Bugwa to check with the registry for the
And
skeletal
one
arguments.
for avoidance of doubts,
Yes.
I can have somebody available, but I know my assistant is before the court. If you can
Okay.
avail the next 2 minutes,
Yeah, please send them to the boardroom and they will be brought to me. Thank you.
most obliged.
Okay.
But you can proceed in the meantime, your lordship?
Absolutely.
Correct. My lord, we have highlighted the application and broken it into 4 links. My lord, which I will address to, and I'll have my learned colleague, Mr. Sige, address the other 2. My lord, the background of this matter is that the Honorable Oscar Sudi was arrested or actually presented himself to Langas Police Station on Sunday, the 13th of September, and was thereafter on Monday, the 14th of September, presented before the Honorable Magistrate, whereupon an application was preferred to have him detained. But notwithstanding that to date, no holding charge or any charge of any nature has been presented against the applicant. My lord, in considering the application to have him detained for a further 7 days, my lord, we wish to highlight the following issues. Number 1, lordship, that the court fell in grave error in finding that the demonstration which ensued pursuant to the statement made by the applicant constituted public interest that will therefore warrant its detention before trial. Whereas the applicant has no issue with the right of citizens to picket, my lord, it was a grave misdirection to hold therefore that demonstration had the net effect of waiving the applicant's right to freedom and liberty. So, holding your lordship, we submit that the court considered extraneous matters and thereby arrived at a completely wrong decision. My lord, we cannot overemphasize the fact that the right of freedom and liberty is a primary right available to the applicant, without which all the other rights, including the right of expression, movement, cannot be enjoyed. Further to that, your lordship, the penal code provides as one of the measures of punishment of an accused person as limiting his movement by way of incarceration. That right is only exercised, or that decision that the court is only exercised after the court has had the benefit of hearing all the evidence, have the same tested through for the examination. And my lord, by detaining the applicant for a period now which would amount to 11 days, that is, if it to be detained up to Wednesday, it would be a period of 10 days, 11 days actually. My lord, would amount to punishing or restraining his movement even before trial. We would urge the court on account of historical issues, where detention before trial was the norm, and the people of Kenya, through promulgating the 2010 Constitution, elected to waive that by making sure that an accused person is presented before within 24 hours. My lord, detention before trial cannot be lawful just because it has been given a seal of approval by way of a decision by the court. The second link I wish to address the court on is the finding by the Honorable Court, or by the trial court, that the applicant would influence witnesses, the subject lordship that in arriving at that decision, trial court fell in error for two reasons. Number one, it completely failed to consider the submissions made on behalf of the applicant before the trial court, especially on the aspect that the identity of the witnesses had not been availed, and therefore the applicant could not interfere with witnesses whose identity was not known. And second, Your Lordship, that on account of the office he held, he was therefore in a position to interfere with the witnesses. My Lord, I will be inviting the court to consider the decision of the International Criminal Court in the case of prosecutor versus Uhuru Muigai Kenyatta.
Just hold on for 1 second. Okay, Uhuru Muigai Kenyatta versus.
With the prosecutor versus Uhuru Muigai Kenyatta and others, the citation, Your Lordship, is ICC.
You provided that?
It will be provided shortly, Your Lordship. It's not been listed, but the matter that came up in the course of the discussion this morning. It's ICC -01 /09 -02-11. Lordship, in that matter, the aspects were one of the prosecutors, the former Commissioner of Police, Hussein Mohammed Ali, President Francis Mudaura, all of whom were very senior government officials. My Lord, the court and the court will take notice of that, still granted them bail. The main consideration being also that they would appear before the court. My Lord, despite the position my client holds, it was still incumbent on the prosecution to provide cogent evidence that he would interfere with the witnesses. The mere fact that there was a suspected commotion in his place does not amount to evidence that he would interfere with the witnesses. Also, but now have Mr. Sige take the other rulings.
Thank you so much for keeping time. That was 9.5 minutes.
Thank you, Lordship.
Okay, that is Mr. Sige.
Yes, my Lord, my name is Mr. Sige, and I will speak on the last two limbs. I'll also try to be as brief as possible. And the first issue, my Lord, is to highlight the fact that the application before the trial court required the interpretation of Article 49 of the Constitution. Now, we submit that the trial court, in its interpretation, gravely erred and failed to be guided by Article 259 1B, C, and D of the Constitution. That error led to a wrong interpretation, which ultimately failed to appreciate the spirit and soul that is exposed in Article 10 of the Constitution that requires proper and good governance. My Lord, in essence, that led to the decision which, as you speak now, has led to holding of the applicant without trial for a period of more than 11 days. Well, we submit that the legal threshold required while arresting a suspect is lower than the legal threshold required for the prosecution to meet in order to be granted the orders which the trial court erroneously did.
The legal threshold for
The legal threshold
lower
in arresting as compared to the threshold that is required of the prosecution to be granted extension for detaining an accused or a suspect prior to being charged.
So let's just call that, for ease of reference, pre-charge detention.
Yes, but
Okay.
in that case, then the court went into error when interpreting that requirement. By the finding that that threshold was met. We submit it was not met. My Lord, support that we have filed the case of Michael Oyamo and others. It's part of the authorities in the fullness of time. I'll invite my Lord to read page 5, paragraph 23 of that particular ruling, where that issue was succinctly explained.
All right.
There is also the case of R versus Nuseiba Osman. It's part of the list of authorities which we have filed. The relevant section, my Lord, is page 6, paragraph 3. We close by saying that in the ruling, it is nowhere demonstrated that the court invited itself as to whether that threshold was met. But allowing pre-trial detention
again, it's pre-charge.
Pre-charge detention takes away the fundamental right of the suspect, which is protected by Article 25 of the Constitution. This right is one of the only four which cannot be limited. It would not have been a coincidence that Article 50 therefore protected that particular right, which by the decision of the trial court, that right has been taken away without meeting the threshold that the law provides. My Lord, the historical development of criminal justice in Kenya is known. It is, in fact, the basis upon which that Article 49 was informed. is aimed at protecting the rights of arrested persons prior to their arraignment and charge. And to support that submission, we rely on the case of Kenneth Omondi Ocheng and 37 others versus the Republic. That is also of notice, my lord, that that case is not among the list that we've done, but we will equally avail it immediately. And lastly, my lord, in conclusion, we submitted that the court, in interpreting the basis of the decision it made, went into grave error. Which we ask this honorable court correct and protect that which the law also protects. We urge your lordship to allow this application and release the applicant. And release the
Mr. Sige, what at this stage the applicant is interested in is prayer B, correct?
Yes, ma'am, that is where I was heading to.
Okay.
That we ask that this court at this point do allow the application and grant prayer 2 with such terms as the court may deem appropriate in the circumstances. My lord, the applicant in his affidavit has undertaken to comply with such conditions as you may grant. We therefore pray that even in the absence of a written reply by the prosecution, this application should be deemed not to have been opposed. I therefore pray that you allow it, and I thank you, my lord. Thank you.
Mr. Sige, just a question for you.
Yes, my lord.
Before Mr. Karuri speaks.
Yes.
To the extent that the state says that it's apprehensive that the applicant may continue making utterances which it deems to be capable of inciting the public and or addressing members of the public in the same regard to which the court, the state considers unlawful. Is the applicant binding himself not to do so, at least during the period of investigation and before the charge?
Thank you very much, my lord. As I have said, the applicant has undertaken in his own affidavit, which is in the, supporting the application,
Yes.
he equally undertakes to keep peace,
Yes.
and comply to the letter of the conditions that my lordship shall give.
Thank you, Mr. Sige.
Thank you.
Mr. Karuni?
I'm much obliged, my lord. My lord, we oppose this application by the applicant. My lord, on the following grounds. Number one, my lord, the applicant should have brought an appeal instead of a revision in this matter. My lord, under section 362 of the Criminal Procedure Code, this court has the powers to call for and examine the record of any criminal proceedings for the purpose of satisfying itself as to the correctness, legality, or propriety of any finding. It is our submission, my lord, that Honorable Carlo, Chief Magistrate, in his ruling, was right in denying the applicant bail in view of the compelling reasons which we demonstrated before him. That there was immense public interest in this matter. And in the interest of national security and public safety, the applicant should be detained to enable police conclude their investigation. My lord, we complied with the provisions of the Constitution, Article 49(1)(g) and H, because we informed the applicant the reason for his continued detention, and we demonstrated compelling reasons as provided for in the law.
And what is the reason for continued detention?
My lord, the main reason for the continued detention is the immense influence the applicant wields on the ground as Member of Parliament for Kapsaret that would make the police be unable to record statements from witnesses who were at the scene.
Proceed.
My lord, we are still conducting investigations even today, my lord. And we are not yet ready to present any charge until we conclude investigation. My Lord, the submission by counsel that we should have preferred a holding charge is not tenable because the same would not be accurate in its particulars as the investigations are still ongoing. And would offend the very foundational principle of certainty of a charge. As provided for under section 134 of the Criminal Procedure Code.
Let's proceed, Mr. Karuri. It seems Mr. Karuri has been frozen out. Mr. Karuri, can you hear us?
Network had a problem, but I'm back.
Oh, you're back, okay.
I'm back.
Well, so very clearly the internet did not like your last point. Please proceed.
Much obliged, my Lord. My Lord, in the bail and bond policy, paragraph 3, 1E.
3(1)(e).
Yes, my Lord.
Okay.
We submit that the court correctly applied the principles in this policy that bail determination must balance the rights of the applicant and the interests of justice. My Lord, we demonstrated that the applicant would undermine the integrity of the criminal justice system by interfering with witnesses, and it was therefore necessary to deny him bond at this moment. My Lord, the interests of justice demand the protection of the investigation process against probable hindrance by would-be accused persons.
The interests of justice demand
the protection of the investigation process against probable hindrance by would-be accused persons. My Lord, my final submission is that if my Lord will be persuaded to grant bail, we would pray that as part of the conditions of the bail, as deposed to by the applicant in paragraph 35 in his affidavit, that he is willing to comply with any orders issued by the court, would be that the court cautions the applicant not to make any insightful utterances. And my lord, I'm happy that you brought up the issue before I commence my submissions that the applicant should bind himself not to make any further utterances. I'm much obliged, my lord. Thank you.
Mr. Harvey, before you speak, I have a question for Mr. Karuri, and then I have a question for Mr. Sudi. I will begin with Mr. Sudi. Mr. Sudi, can you hear me?
I hear you, Ahora.
You can hear me, Mr. Sudi?
I hear you, Ahora.
Okay. The question for you is, now we are at even pre-arrangement stage, and so I take this to be more of a inquisitorial process. So I wanted to find out from you, as you know, the Constitution grants you the freedom of expression, freedom of association, and so forth. But sometimes people can choose to forego some of those rights in view of other welfare-enhancing considerations. So the question for you would be, you are roughly aware of what the state is complaining about, the statements you made. Am I right?
Right.
Are you willing not to make those kinds of remarks, whether they are insightful or not? Are you willing to bind yourself not to make them, at least until you are charged?
Yes.
You are?
Yes.
Thank you. Mr. Karuri, a question for you. So, you relied very heavily on the influence of the applicants. And I'm just wondering, quite objectively, is the influence of the applicant any less when he is at Nakuru Central Police Station? Does it drastically go down in threat that now he is being incarcerated here?
My lord, in my view, it does. The fact that he's at the police station,
yes,
has greatly cooled down the temperatures on the ground. This is my objective view, my lord.
Mr. Karuri, for keeping within time, and now we have Mr. Harvey.
My Lord, I'll make it short.
Yes.
My Lord, it has been submitted by my learned colleague, Mr. Daniel Karuri, that the applicant ought to have lodged an appeal. Lord, an appeal would not have been the appropriate reprieve for two reasons.
Yes.
One, we don't have a criminal case yet. We don't have a criminal case yet because the applicant has not been charged.
Yes.
And now, even if the applicant had been charged, it is strike law. The latest decision being won by the Supreme Court a week ago, that no appeal lies against an interlocutory decision in a criminal matter. It's strike law. It was submitted by my learned colleague that there was compliance with Article 49, sub-Article 1, paragraph G, to the extent that the applicant was informed of the reason for the detention continuing. Lord, it is indeed true that he was informed. What was the information given to him? That we cannot release you for the reason that as the honorable member for Kapseret, you are so influential that we cannot investigate this matter unless you are held pending charge. My Lord, there are two birds. One is an eagle with a very big wingspan. It can fly for 100 kilometers without patching. There is also another bird called a quail. Where I come from, we call it isindu. It cannot fly for over 50 meters. You cannot tell the eagle that thou shalt not fly because you have a big wingspan than the quail. Honorable Sudi will continue being the member for Kapseret until 2022 unless something else happens. So if that be the reason, then that is not a good reason for detention. Lord, lastly, we've been told it is in the public interest and the interest of national security to continue holding the honorable member of the National Assembly for Kapseret. My Lord, it has been said by courts time without number that where there is a contest between national security and a right in the Bill of Rights, the right must of necessity prevail. That is why here we have mad men outside there making noise. It is their right to be mad. Lord, on the issue of public interest, again, it has been said time without number that public interest is best served by upholding the law. Lord, we beseech you to uphold the law. This is a matter where the honorable member for Kapsaret should not even be asked to post cash bail. He should be released on his word to keep the peace. We have beseech your lordship to release the honorable member of Kapsaret so that he may glide for 200 kilometers to his people. Let the quails fly 50 meters, then the eagle fly for 200 kilometers. That is our plea, my lord.
Thank you, Mr. Harvey. Let me thank all the council for really keeping it very short and for keeping it very civil. I must appreciate that. This is the way we knew the practice of law a long time ago. And Mr. President, you have a big job to return this kind of practice.
Thank you, my lord.
I will, it's now 11:10. Allow me to take about 2 hours to consider the applications and the submissions and the representations before the court. And then in about 2 hours, I'm not promising the ruling will be ready, but at least you will get information from my assistant if it is ready. If it is ready, then a Zoom link will be sent and I will read it just like we've done here. Does that sound okay?
That's 5 my lord. Almost.
So for now, but for now, let's say I will read the ruling at, actually let's make it more certain. I will, let's put the ruling at 2, unless you hear from my assistant otherwise that it's not ready, then we will tell you when it will be ready. But for now, let's plan to come back at 2.
Thank you.
Paul, I think you have done?
Yes, yes.
Oh, thank you.